And counsel, you're on this side. Good morning. All right. So your attorney has informed me that was recently hired. So the last time we were here, there was some discovery issue with his criminal history. Something about his criminal history.
We do have his NCIC, TCIC in the file.
Okay. All right. Then what we're going to do is I'm going to give you one more setting for discovery.
Thank you, Judge.
And state at this date, you need to be prepared to tender an offer.
Yes, Judge.
All right, Ms. Ferguson, I need a 30-day reset. October 20th?
That's fine.
All right, so what's going to happen is you're going to come back on October 20th. By then, hopefully your counsel will have all the discovery and the state is going to tender an offer to you. Once they've tendered an offer to you, I'm going to give you another reset date so you can consider that. And that next date will be your plea deadline date. And if things are not worked out by that date, then your next setting is going to be a jury trial date. Do you understand? Do you have any questions about anything?
No.
All right, so we'll have you brought back. If you're still in custody, you'll be brought back on October 20th.
Okay.
All right, thank you. Thank you,
Judge.
counsel. All right, David Huff. All right, so this is where he's going to be released to go to a different county.
So Judge, he was given a PR bond, I believe, over in Howard County.
Mhm.
Howard County refused to come pick him up to resolve the outstanding cases. So I do have something that I would like to present to the court.
Yes.
Possibly go ahead and release Mr. Huff. Have him report to his CSO within 24 hours of his release. Report weekly, submitting weekly UAs. For him to get a chance to address his pending charges. We would request the reset date for self-surrender for state ISF. For 3 weeks, just to see if the cases have been resolved. If they have not been resolved, then they.
And what cases does he have in Howard County?
Judge, it's an unauthorized use of a motor vehicle case, and I can provide a little insight, Judge.
Yes.
His reconnected with his family members. There is a strong likelihood, based on my conversations with my client, he was in custody at this time, and his brother might have provided an ID or something, so it's potentially a case that should go away. But we didn't know about it. It wasn't fitting. My client wasn't aware about it because it wasn't his case to know about, Judge.
All right, just 1 second, because I don't like cases to be out there and not solved. Could I see someone from the state? On this case, he's supposed to be going into inpatient treatment, but he can't go because of Howard County. Howard County said they're not picking him up.
Okay.
So is there any way you can get in contact with the prosecutor in Howard County just to let them know what we're doing here, and maybe they will dismiss his case?
Okay.
So is that possible?
I can try to reach out to somebody.
All
Sure.
right, so let's see if we can get this solved today.
I might ask, could you potentially consider holding holding in abeyance and letting him do an intensive outpatient, Judge? My client has been doing some work in the jail and I have an update there as well.
Tell you the reason why I have issues with that. And it's just based on things that have happened in the past. People always do well when they don't have controlled substances readily available. So first, I still may do what's being suggested, but first let me see if the prosecutor can talk to the prosecutor in Howard County to see if they can get that dismissed. If the answer is no, then I will consider what you all are recommending. And the reason why is because they've done an evaluation and they're the professionals, and they're saying that you need inpatient treatment. So let me just see what she says. She's going to call them right now, and let's see, they may dismiss it.
My client is prepared to make arrangements and in touch with people like Lifetime Recovery. He's got a sober living home set up when he go. He reminded me that he has 120 days of daily sober support meetings. He's been doing that in jail.
Well, the problem is, like with Lifetime Recovery and everything, I don't know if he'll be precluded because he has open cases in Howard. So let's just see if we can get the open cases taken care of. If we can, great. If we can't, then I'll do something else.
I thank you, Judge.
Thank you,
All
ma'am.
right, but something's gonna happen today.
Yeah, perfect.
All right, thank you. All right, Jorge Luis Martinez.
I am here with that, ma'am.
All right.
Sorry I wasn't in here early because I had received notice it was dismissed because he's been accepted into PTD and he started it.
Oh, yeah, no, it doesn't get dismissed till they're completed it.
Well, I got the notice that it was dismissed.
Oh, so it's been dismissed? All righty.
The system is still state duty, the correct dismissal, to correct.
All right, so on the system, it's been dismissed.
Yes.
All right. And thank you for dressing appropriately for court. I hope you've learned some things. All right, don't come back to a court unless you're just coming back to visit, okay? All right, have a great rest of your day.
Thank you, you too. Thank
You're
you, ma'am.
welcome. Thank you.
Yeah, so they. So there is something. I'll let you.
Okay, sure. Your Honor, may we vote?
Yes.
I did get a hold of the district attorney in Howard County, and he said he, based on his review of the report, he doesn't have a problem dismissing it as long as he can get something from us with the cause number showing that he is getting sent to an inpatient treatment facility.
Okay.
So Vashon's gonna send me a copy of the amendment, and then I can send it to him, and then we should be good.
Okay, sir, if you can come down.
What do we serve?
Hello. All right, so things worked out beautifully. So they're gonna dismiss your case, but they're dismissing it because we're sending you to inpatient treatment, okay? So you will be done with whatever's happening in Howard County.
And I'll work with them today. We'll make sure that they got what they need to get.
No, I'm going lifetime, you know?
No, if they are saying ISF, however, if you want to speak with probation, and if probation feels that inpatient treatment of lifetime recovery is better, then I'll consider that. But it's going to be an inpatient facility.
Okay.
All right.
Thank you. Judge.
And that's per your, the request for the other county in order for them to dismiss your cases.
Okay.
Okay.
Thank you, ma'am.
Thank you.
All right, thank you. All right, Ruth Payne.
Morning, Your Honor. May I
Good morning. Yes, and I'm sorry, counsel, you're on this side. Hello, good morning, and thank you for dressing appropriately for court. I really do appreciate that. So my understanding is that you've signed for PTD?
Yes, Your Honor.
All right, so we're gonna bring you back on October 20th. So just make sure you follow whatever conditions they're setting for you.
Okay.
All right, do you have any questions about anything?
No, ma'am.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
Thank you so much.
Everybody
Thank you.
excused.
Yes.
That's great seeing you.
Oh, once you sign the reset, it's already ready. Mr. Rios,
Yes, ma'am.
you need to show your video, sir. All right, so probation will be contacting you.
Yes.
All right, so you're excused.
Thank you, ma'am.
Welcome.
Your Honor.
Yes,
May I approach that?
yes.
I just got a text from my advocate that the victim did get back with her, and the victim said she paid $1,000 out of pocket.
All right. If you could call Mr. Rios to come back in.
I'm sorry, Your Honor, I
That's
just got
okay,
it.
no problem. All right, are the parties here on Luttrell Miles?
Yes, sir.
Where's Mr. Miles?
He's in the box, Judge.
Oh, Mr. Miles, if you'll come down. All right. Court is calling 2022 CR 2755, State versus Luttrell Miles. Could I have parties announced for the record?
Lauren Espinoza for the state.
Andrea Matos for the defense.
And are you Mr. Luttrell Miles?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Lutrell Miles who was placed on community supervision in 2022 CR 2755 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on July 13, 2023 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, states proceeding on violated condition number 4 of the supplemental MTR, which reads,
All right, just one moment. Does anyone have a copy of the supplemental? I don't have that. All right, thank you. Thank you, Michelle.
You're welcome.
Mr. Miles, did you review the supplemental report?
Yes, ma'am.
All right, state, you may proceed.
Violated condition number 4, in Bexar County, Texas, the defendant Latrell Miles did then and there fail to report to the supervision officer as directed for the months of December 2023, January, February, March, April, and May of 2024 in violation of condition number 4.
How do you plead to that, true or not true?
True.
All right,
We would waive all others, Your Honor. And then as for an agreement, we would ask that you grant state's motion to revoke, sentence Mr. Miles to 3 years in TDC, and as well as take into consideration clause number 2025 CR 005391.
I'm sorry, could you repeat the cost number?
2025
Mhm.
CR 005391.
All right. And defense?
Yes, Your Honor, that is our understanding of the agreement. We ask that you follow that recommendation by the state and probation and follow the agreement.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
That's Robert Shea Miles.
All right, why have you not been successful on probation?
When I was put on, when I was giving me his probation, I'm a plumber, doing the UA testing in the morning every day to go to work. I wouldn't be able to go out to go to work, and I wouldn't be able to buy it. So I thought,
You didn't even report.
I did 3 times. The lady, she told me that I would have to call, and I'm a plumber. In the morning, we have to go out to work. I can't. I mean, if I would have been able to do it in the afternoon, yes, I could have made waves, but in the morning, I couldn't. So
So here's the question. Why do people think when they're on probation, it means that they don't have to report? I don't understand that. Because here's the thing, when you're on probation, you're not like regular people in the sense that you can just go do whatever you want to do. Otherwise, people would place people on probation and say, just don't pick up another case, which they're taking something into consideration. So it appears that you picked up a new case as well.
yes, I did.
So
ma'am.
you had time to pick up a new case, but you didn't have time to report or call your probation officer.
I understand it's a privilege of being on probation, ma'am. I've been in drug court before. I understand.
Mhm. All right, so let me just explain something to you. I am going to grant the motion. I am going to revoke you. But if you continue on the path that you're continuing on, you're either going to end up at somebody's prison for the rest of your natural life, or either somebody's going to come out and identify your body because the last time you use is going to be maybe the last time you use. You understand?
I understand, ma'am.
All right, the court is going to grant the motion, revoke, taking consideration 2025 CR 005391, sentence you to 3 years in the prison. And are you waiving your right to appeal?
Yes, I am, ma'am.
And are you asking the court to follow this agreement?
Yes, ma'am.
All right, the court will give you credit for any time served. I'm going to request the therapeutic community. The therapeutic community does not increase the time that you're in custody. So for example, you received 3 years. I followed the agreement that you reached. If they are working with you in the therapeutic community and they say, oh, your 3 years is up, but we want to spend more time working with you, they don't get to keep you. The most time you can get is 3 years. That's it. And if you are paroled before 3 years, they don't get to say, we don't want him paroled. We want him to continue working with this class. The therapeutic community is just designed to give you tools. So hopefully you will be able to control your addictions and be sober. You understand?
Yes, ma'am. Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes,
All right. And I'm sorry, one other thing that I'm going to order is no unsupervised contact with minors. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own. Oh, I'm so sorry. The correct cause number for the case that's being taken in consideration is 2025 CR 005391. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
thank you, ma'am.
You're welcome.
Thank you, Joe.
You're welcome. And Cindy, in case I didn't say it and the record isn't clear, I found violation of condition number 4 true. Yes.
Our advocate just spoke to the victim on that restitution
Mhm.
case. She's currently receiving medical treatment, so she's not in a position to get us the documentation right now.
Okay,
Is it-
does she have the documentation though?
I don't know the answer to that yet.
All right, if you can find out if she actually has it in her possession, then we can just reset it. But
Okay.
if it's something else,
She did mention her insurance company, USAA, so I don't know if she's relying on us to go get it through USAA ourselves. I did leave her voicemail explaining that that would take a long time,
Mhm.
so I'm trying to find out if she's got anything personally.
okay.
I don't know if she's in a position to like have a long conversation with what she has going on medically, but I'll let you know.
Yeah, just so we can reset it so she can get it. All right, David Guerra. Hello.
He's not here.
No, he says that he is ill.
Oh, okay.
So he's saying that you're requesting a jury trial.
Yes, ma'am, because I told him.
No, here's the thing. I can't discuss
Oh, okay.
whatever
I'm sorry.
you've discussed with your
Yeah.
attorney. That's supposed to be confidential. He
Okay.
probably doesn't want it discussed with me. And I'm not allowed to discuss with you about
Right.
what you say the facts of the case are. So what we're gonna do is we're gonna set it for a jury trial, okay?
Yes, ma'am.
State on Guerra, page 7. How long do you expect that trial to last? All right, Ms. Ferguson, I need a jury trial date, 3 days. All right, we're gonna set you for November 12th for jury trial, and
Okay.
because your attorney is not here,
Okay.
Norma, make that a jury trial in a plea deadline date. All right, once you sign the reset form, you excuse.
Okay, thank
Okay,
you.
thank you. Thank you for dressing appropriately for court.
Can we get both?
Yes.
It's a matter that's set for tomorrow. And if the court would indulge us, if we would have a short conference in chambers.
Sure. I'm all about indulging people.
Maybe approach it.
Yes.
Oh, I'm sorry. Or I didn't know if you needed to give it to the clerk.
Okay.
Oh, Sorry. We were confused, Judge.
Oh, he also had a bond motion, so,
Yeah.
when we were back there, he was talking about that as well.
Okay, so here's the thing about bonds now. Thing, it's gonna have to be done by Zoom or something.
Okay.
So, and then with regards to that, I have to put in the record whether or not they have absconded or didn't show for court settings. That has to be taken in consideration. And we can do it by Zoom, and you can put on the record, you know, if he was in the hospital at the time or whatever you want to put on the record, you can put that on the record.
Okay.
But now we have to make sure that everybody's present. So
Of course.
I can pick that up.
Okay,
whenever you're ready for that, just arrange it with Ms. Ferguson.
okay.
And Norma, on this cause number 2024 CR 4123, his client is actually has medical issues in the hospital. So let's recall this for 60 days. And then if he's still in the hospital, because I know sometimes,
He's actually back at the jail, but he got no physical therapy whatsoever.
oh, well, I
It's
mean,
just like one day.
oh, you need physical
Oh,
therapy
and that's part of why we're trying to
Yes.
work out the bond aspect, so.
and potential infection when you've
Yeah.
had limbs removed. All right, what date? So we'll set it for November 13th. And if y'all want to see, maybe Miss Ferguson, Norma, he's at the jail. Do you think you'll be able to get him on by Zoom? He had some amputations done. So you can see if maybe we can get a Zoom with him today and take care of it today.
That'd be fine.
That'd be
All
fine.
right, so if you'll, Norma will let you, well,
Whenever.
we're gonna try to get it done this morning. So if you'll remain and speak with Miss Ferguson about that.
Absolutely. Thank you, Judge. I
All right,
appreciate
you're
it.
welcome.
I'll-
All right. Joaquin Mendez,
Morning, Your Honor.
good morning. So your client is still in federal custody?
Yes, Judge, still in federal custody.
All right, do you have an update or a date?
I do, 18 September, we're supposed to do sentencing. So keep your fingers crossed.
All right. All right, Ms. Ferguson, on this, counsel, if you confer with her and see about a date in October,
Yes, Your Honor.
that will be good for you, and then just come back and let me know.
Thank you, Your Honor. Appreciate
You're
it.
welcome. All right. Counsel, you have a date?
14 October, Your Honor.
All right, thank you.
Thank you.
Have a
Judge.
good one.
You have a good day.
You too. I just let the state know. State, on page 7, Mendez, defense counsel said that he should be sentenced in federal court sometime in September. So we're recalling it for October 14th. So if you all can probably see if he's actually been sentenced at the beginning of September and then bench warning. All right, thank you. Yes. All right, Cassandra Garza.
Here, Judge.
Okay, oh, she needs to be.
Oh,
Morning, how are you doing today?
Fine.
Oh, that's good. Let me just pull up your case. All right, so where are we on discovery?
We have the original reports and everything. I don't think discovery is gonna be an issue with this case. It's pretty easy. Give us a yes.
All right, did the state tender an offer?
They're reviewing the file for an offer. There's actually an issue getting filed down for the
PD, Judge.
Sorry,
We're gonna review for PTD.
okay. And how long will that take you?
Oh, not very long at all, Judge. We can reset for whatever the court feels is proper.
All right.
I think it's the first setting you're on.
Okay. All right, Norma, in this case, the state is considering PTD. Could you recall this in 2 weeks, please? And it is Cassandra Garza on page 6. Okay, October 6th, council.
I believe that day is good, Judge. I'm checking it right now.
Mhm.
Are you gonna be in court on the 7th, Your Honor?
Let me see. Norma, can you place this on the 7th? All right,
Thank you.
once you sign the reset form, you're excused.
Thank
All
you,
right,
Your Honor.
thank you. All right, Ms. Trevino. Ruth Trevino, hi, if you come forward. Hello, good morning. All right. So are you available to come back this afternoon?
Yes, ma'am.
All right, so what's gonna end up happening, this says ex parte. And ex parte at the top of your form means that I'm the only one who should see it. But when you're filing a request for an occupational license, I'm not the only one who's supposed to see it. The state has to see it because of the new laws. They have to do their research to see if there's anything in your past that will preclude you from being granted an occupational license. Normally, I would say in the 90s, you could just file a motion for occupational license, the judge would sign it automatically. But now the law has changed, so I just need them to be given some time to do some research, and I don't want you to have to take off again. So if you can come back at 1:30, that would, all right. All right, thank you. And thank you for addressing appropriately for court. I appreciate that. All right, we'll see you back at 1:30.
1:30?
Yes,
Yes, ma'am.
thank you. State,
Yes.
this is a request for occupational license from her. If you all could review it and review her history.
Yes, yes, ma'am.
All right.
1:15.
Yes, she'll be back at 1:30. All right, who's here on Candace Cox?
Ready, Judge.
All right.
Don't remember what side I'm on, Judge.
Oh, this side. That was a move that was requested by the deputies for security reasons. Because defense attorneys were on this side. All right, the court is calling 2022 CR 5387, State versus Candace Cox. Can I have parties announced?
Melissa Alvin for the state.
Scott Hill for the defendant, Ms. Cox.
Defense. Can you ask them to move down there, the attorney? Thank you. All right, we're back on the record. And you are Ms. Cox?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Candace Leah Cox who was placed on deferred adjudication in 2022 CR 5387 for the offense of possession of a controlled substance? All right, we're going to go off the record. All right. With regards to the motion to enter adjudication of guilt and revoke community supervision, any requests from the state?
Yes, Your Honor, we'd like to make an oral amendment to the allegations as far as the offense that she was placed on probation for. It should read possession of a controlled substance, penalty group 1 less than 1 gram.
Any objection?
No objection.
All right, Ms. Cox, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Candace Lee Cox.
All right, Ms. Cox, the state is requesting an amendment to the motion to enter adjudication of guilt and revoke community supervision. They're asking that it be amended to include the words possession of a controlled substance, penalty group 1 less than 1 gram. That's a substantive change. Do you have any objection to continuing with that change?
No.
All right, and are you waiving notice?
Yes.
All right. State, you may proceed.
Your Honor, we'll proceed on violation of condition number 41, the last condition. On or about the 21st day of February 2023 in Bexar County, Texas, the defendant Candace Leah Cox then and there failed to comply with the rules and regulations of the felony drug court, and that the probationer absconded and illegally removed their GPS monitor. This is in violation of condition number 41.
How do you plead to that, true or not true?
We'll waive the rest, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not an agreement, Your Honor. We're recommending revocation in 1 year in the state jail, and I think Mr. Hill is asking for something different.
Yes.
Judge, I can put her on as a witness as well as her mother, but just to give you the Cliff Notes version, right now, she understands. Her mom, she had a serious drug issue back when she took this plea back in I think, early 2023.
Mhm.
Her mother, who is Miss Juanita Garcia in the wheelchair, to protect her daughter, who was 6 at the time, moved her and her husband sitting right behind her,
Mhm.
moved down to Corpus Christi and took her daughter.
Mhm.
She could not be without her daughter. So she did something she shouldn't have done, and she understands that.
When you say she could not be without her daughter, are you talking about your client's daughter?
Yes, Judge.
Okay.
So irrationally, she admits that she made a mistake. She just moved down there. And her daughter was 6 at the time. She didn't want to lose contact with her. Now, her mother did that to protect her 6-year-old because she had a drug issue at that time. When she moved down there, her fiance went with her. Not too long after that, her fiance passed away in her arms, had a heart attack, and that has completely just changed her. She's not doing drugs anymore, Judge. In a fate of irony, Judge, her disobeying and breaking the conditions of her probation has actually propelled her. Not that it has anything to do with that, but she found herself, Judge. She got help. She's been clean for over a year. She's solely responsible for taking care of her parents and her 9-year-old daughter. So everything is going great in court. Now that doesn't, I'm hoping that the court will consider, because she's doing so good right now, and you can hear from her mother in a second if they need to extend her probation and maybe transfer it down there. She's happy to do whatever the court wants her to do, but sending her, she knows she deserves to probably do a little time for what she did. But I think that in the long run, it's going to hurt her mom and her dad and her daughter even more, to the point where the state will probably take custody of the daughter because the grandparents aren't physically able to take care of her. So those are the issues I want to. And if you need to hear from some witnesses, I'm happy to put them on.
All right, well, what I can tell you, here's my issue. Number one, I don't know if you've been cleaned or not because you didn't report. I don't understand why you would cut off your GPS and leave Bexar County when I know that felony drug court would have addressed those issues with you. So what have you done on probation? Other than cut off your GPS monitor and leave to go live with your mom when your mom removed your daughter from this situation because you have a drug addiction. So what have you done?
I've just been taking care of them.
No. What have you done on probation?
I made a visit,
Judge, I think
visited with the probation officer.
she had one visit. It happened like right after she was put on deferred, Judge. I think she had one visit and then she left.
Okay, that's a problem. I mean, because felony drug court is there to help you, and what you just pled to is you removed your GPS monitor and you absconded. And you were on probation. And what you did was you took up a space that somebody else could have had because felony drug court, they're always at capacity because it's a very good program and it's to help people with drug addictions. So basically what you did was you cut off your monitor after your parents had left. And the reason why your parents left and took your daughter with them is because you were not an appropriate person to be around a 6-year-old. So what did you do? With your drug addiction, you cut off your GPS and then you left. I'm not going to continue you. I'm going to grant the motion and I'm going to find you guilty. I'm going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's to be no unsupervised contact with minors. And I'm going to recommend the therapeutic community. I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Hello.
How was your jury duty experience?
Oh, it was great. You know, now I can say I've basically been in every position on the criminal side. I've been a defense attorney, prosecutor, judge. I've been a juror, and I've been on a grand jury.
You haven't been a defendant, so that's good.
Okay, yeah, let's not make me a defendant. But I have testified before for one of my clients. It was in Judge Carruthers' court.
Huh.
And it was a competency issue.
I had jury duty not too long ago and
Mhm.
got put on a panel. I mean, there were 500 people in the room and
Mhm.
everybody went out except for 30 or 40 people. And
Now, well, this
I
time,
was one of the 30 or 40. It's like, oh.
well, this time, let me just tell you, I got called up. I was juror number 16, and then they did a shuffle. And then I became juror number 7. How often does that happen? Usually only move one space, right? And I think, yeah, and I think they were trying to get me towards the end. I'm like, hey, I can be fair. If somebody is, you know, if the state prove their case, I'm gonna find them guilty. If they don't, I'm gonna find you not guilty. And I'm the one who, hey, it doesn't matter to me if it's midnight, 2 a.m. I'm like, yeah, I'm still here. You know, I'm not gonna say, oh, I'll do this so we can go home. No, that's not me. I will stay. I would try to figure out a way though, if we're sequestered, to get a room by myself. You know, they need to change that because you're in a hotel room with a complete stranger. So I'm gonna work on that. And I'm gonna have to do some research. I don't know if that's a law or if the county is saying, hey, we can't afford that, so you have to share rooms. Oh yeah, I'm gonna change that.
Weird.
Well, you know what? We actually had Deputy Laura told me we once had a juror who said, hey, I'll pay for my own room. You know, let me have a room, and they're like, no, we can't do that.
Staying on with a stranger.
I'm gonna work on that. I know that means you guys will be on too many floors. Oh, he's here. Is he a Spanish speaker? All right. Well, as soon as, oh, Mr. Spears, you're here? Could I have that file back on Aguilar, please? Yeah, it's a motion. He's not on the docket. It's off docket. It's a motion for a bond. I think I just sent it. Oh, you have it?
Then that was my paperwork. It-
Oh. Okay. All right, we're gonna go on the record. Cindy, are you ready? Yes.
That's the motion. I'll give you the order.
Okay. Court is calling 2024 CR 4123, State versus Miguel Aguilar. Can I have parties announce?
Stephen Spear for the state.
Tony Hernandez on behalf of Mr. Aguilera.
All right, Mr. Aguilar, are you able to unmute, please? If you'll hold down on the space bar, it's the longest key on the keyboard. Right, so what you'll, let me have them on my.
Yeah,
Okay.
you're muted.
Thank you, Deputy. Are you Mr. Aguilar?
Yes, ma'am.
All right,
Aguilera, Judge, I'm sorry.
Aguilera, all right, thank you.
They've got it wrong.
They forgot the R. Mr. Aguilera, could you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth to help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Miguel Ángel Aguilera Jr.
All right, Mr. Aguilera, you are entitled to appear in court in person. Do you have any objections appearing by Zoom?
No, no, ma'am. No, ma'am, not a.
No.
Objection? All right, we're here because your attorney has filed a motion for a bond, is that correct?
That's correct. Yes.
And is he on deferred adjudication or no?
It's an unadjudicated, Judge. It's an open case.
All right, because it has.
Oh, I'm sorry.
Oh, that's okay. All right, so there's a request for bond. Is there an agreement on a bond amount from either side?
There is, Your Honor. I believe the previous bond had been $5,000. We have an agreement for $10,000 subject to courts.
That's correct.
All right. And just give me one moment.
I never filed for it, but if it was in the state of Texas, I would say no, but actually, there was I believe there was $160,000. Mine is 30,000, there's no way I can avoid that. Also on my credit report or something like that, that I'm not, I'm unaware of, so yes, there is, I believe that now before.
All right, defense. The court will note that the reason he doesn't have a bond, he previously had a PR bond. It was revoked because he didn't appear. So call your client as a witness to address those issues for the court on the record.
Thank you, Your Honor. We call Miguel Aguilera.
All right, Mr. Aguilera, you're still under oath. Your attorney has some questions for you.
Recall that, past January, you were set in court, is that right?
Yes, sir.
Okay,
Now,
so.
You've had some ongoing health issues to deal with, is that correct?
Yes, sir.
And has that caused you to be in and out of the hospital on numerous occasions?
On many occasions, sir, it has, health-wise, I'm limited to my mobility and to function at all. Where's it at?
In fact, prior to January, when you showed up in court, you showed up in a wheelchair, is that right?
Yes, that's correct.
In fact, by the time January came around, you completely lost use of your legs, is that correct?
Yes, sir. My lumbar spine was fractured.
And in January, when you were supposed to appear, you were actually in the emergency room and then later in the hospital, is that
Yes.
correct?
That's correct.
Thank you. And you've got some ongoing medical conditions that just recently resulted in some amputation, is that right?
Yes, sir. Both legs, yes, sir.
That was just within the last 2 weeks, is that correct?
That's correct, sir.
If the court were to set a reasonable bond in this case, can you assure the court that you will show up to court when you're supposed to now?
I'm 100% sure I can, Mr. Hernandez.
Thank you, Judge. Thank you, Mr. Aguilar. We'd pass the witness.
And Your Honor, I don't have any questions, but I just, as a discussion off record, I did want to note from discussing with defense counsel, I believe Mr. Aguilera needs some physical therapy, and at least at this point at the jail, he's unable to receive those. That's part of the reason for the state's agreement with defense.
All right.
And that's correct, Judge. I apologize. Oh,
So
no.
both parties are in agreement to setting the bond at $10,000?
Yes, ma'am.
Yes, Your Honor.
All right, this is going to be the court's findings. The court is going to find that your client does need services that the Bexar County Jail could not provide. And those are related to rehabilitations due to the double amputation. The court is going to note for the record that there are some issues with regards to potential infection that may happen at the Bexar County Jail based upon his double amputation. And also the court is finding that, and both of you all agree that a doctor states that due to the double amputation, he is going to need some form of rehabilitation to regain the ability to walk or to obtain prosthetics. So with that being said, the court will follow your agreement, set the bond at $10,000. Any other conditions that are being requested from either side?
Your Honor, the only thing I could possibly think of, and I think these cases have already been adjudicated, is no contact with the co-defendants.
All right. And there's to be continued no contact with co-defendants. And when would you all like this recalled?
I believe the court had indicated earlier that it would be 60 days.
Yes.
I believe it was November
13th.
13th. Yes.
All
Okay.
right. So Mr. Aguilera, your next court date is going to be November 13th. Could you hold down the space bar for me, please?
Yes,
All
ma'am.
right, Mr. Aguilar, you're going to need to be in court on November 13th at 9 a.m. Do you understand?
I understand, ma'am.
All right, thank you.
Thank you, ma'am.
Welcome. All right, so he'll be excused and we'll see everybody back on November 13th.
Thank you, Judge.
All right, and if you let them. All right, what you have is on today's docket.
It's actually tomorrow, Judge, but Steve's gonna be out tomorrow. That's
All right, what's the cause number?
825 CR 000615.
Is that Joseph Juarez? All right, so we're supposed to be scheduled for jury trial on the 16th, which is tomorrow. So what's going on?
The judge, we have two experts lined up. One, Dr. Fagan, supposed to do an evaluation of my client. It hasn't happened yet. So he's already been appointed. The order's been signed.
Okay, why hasn't that happened?
I'm not sure. I'm gonna follow up on that. But there's also an expert on the cell phone extraction. I know that he's already gotten in contact with SAPD to make the appointment, but trial's moving a lot faster than my experts are, obviously. Although in my defense, I would say those orders were signed maybe a month and a half ago. Hasn't been like months and months ago.
All right, Ms. Ferguson. Recall this for jury trial in October. So you guys need to get a date for Ms. Ferguson for October 8th.
Yes, ma'am.
And then let me know what that date is.
Will do. Thank
All
you,
right,
Judge.
you're welcome.
October 28th, Judge.
October 28th.
Yes, ma'am.
All right, see you all back on October 28th.
I do appreciate it.
All right, thank you. Anyone else ready?
Yes, sir.
Ricardo Ramirez. All right, court is calling 2023 CR 9472, State versus Ricardo Ramirez Jr. Can I have parties announced?
Louis Martinez on behalf of Mr. Ramirez.
All right, the defendant has previously entered a plea of true on the motion to revoke, and we're just here for the court to sentence.
Correct, Judge.
All right. Yes.
Judge, so Mr. Ramirez, the court had sent him to adult drug court with the idea he was perfectly willing to do that. When he gets there, he just doesn't qualify because his needs aren't great enough for that. We wanted to address the status issue with the court, didn't have a chance to do that before the MTR was issued. But we're here, we've conferred with probation, I've conferred with the state. What we think is appropriate, given his needs and given the TAP evaluation and what drug court found. We're hoping that supportive outpatient and a year on scram, there's a new scram bracelet, would be sufficient for the court.
All right.
Judge, Steve Jarvis was here, on Thursday when we were kind of looking over the case. And the recommendation that's listed on the court summary, he did not agree with. We combed through on the court summary and on the TAP evaluation, we combed through the case, and based on the violations that were presented, we just felt like status would not be the best option, and it would just be overkill, basically. So we did come up with a plan for supportive outpatient treatment, and then getting him on the track watch if the court.
Oh, but that's correct, Your Honor. We all kind of conferred together, and that was what we came up with.
Okay. Anything you want to say? You
Um,
want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Ricardo Ramirez.
All right, what do you want to say?
Yes, ma'am. I was issued the initial MTR in January and I've been compliant ever since. No major violations. I've been working hard on complying with everything that the court has issued. Working, and I am working. I have a good job. Status would require me to leave that job, which I've been at for almost 12 years.
Mhm.
It's very important.
So here's my question for you. So obviously, someone believes you need some type of treatment. And what I can tell you, when you get to the point where it's a DWI third, obviously you're a person who has a problem controlling alcohol intake. So the only issue we're here for today is whether or not I'm going to send you to inpatient treatment, or whether or not I am going to follow the agreement that's been reached. So what you need to focus on with me is not that it's going to cost you your job or any of that. You need to focus with me on what have you been doing to maintain your sobriety. So tell me about that.
Yes, ma'am. I've been going to AA regularly. I completed the initial counseling that was recommended in the original probation.
Mhm.
I made sure I finished those classes and obliged by by your judgments.
And how often have you been doing AA meetings?
A few times a week,
All right, so what do you mean by a few times a week?
2 to 3 times a week.
Okay, and you can continue. What else have you been doing?
I thought you were on Scram for a while.
I was on Scram, so the initial MTR back in January had me at 30 days on Scram. I was on it for about 60 days, no violations. Still on the pen, still on the breathalyzer unit, just to show you that I am committed to sobriety. So I've had no major violations since January, so almost 9.5 months. I am dedicated. I am willing to show you that I am dedicated.
All right, so this is what you need to realize, and this is what I tell a lot of people. So if you are unsuccessful on this probation, you're looking at potentially 6 years in the prison. And you know, if you end up going to prison, you're probably going to lose your employment. You understand? Probation. So, do you think he needs the intensive outpatient treatment? Or do you think continuing with sober support meetings isn't?
Judge, I would say the supportive outpatient treatment, in addition to, at a minimum, in addition to his sober support meeting.
All right, so how often do you want him to do sober support meetings?
Twice a week.
All right, so number one, you're gonna have to do NA or AA meetings 2 times per week at a minimum. Do you understand? Now, if you need more than that to maintain your sobriety, of course you can do more,
Yes.
but at a minimum, 2 times per week. Do you understand?
Yes.
And then they want supportive outpatient treatment, so I'm going to order that. And then with regards to the alcohol monitoring device, what are you requesting?
He's currently on the portable device, the portable handheld device.
Mhm.
Another way that we can track alcohol monitoring is either increase the amount of times that he flows into that device or put him on that track watch, Judge.
Which is the least expensive?
Well,
Because it's the track watch. How much is that?
that one's the one that's either $5 or $10 a day.
So track watch, that's $5 to $10 per day.
Mhm.
So you're looking at about maybe $150 a month, or perhaps $300 a month. Or you can remain on the other device that you have, and you're gonna have to blow in it more than what you're blowing into the machine for testing.
I'm okay with getting the device and doing it more often.
All right, how often do you?
How often does he currently?
3 times a day.
3 times a day?
Yes.
Every day, right? There's no,
Every day.
yeah. 5?
And that's,
feasible?
I think that's feasible if.
All right, then it'd be testing 5 times per day. All right, is there anything else?
Nope.
All right, thank you for addressing appropriately for court. They'll go over conditions with you. Make sure you follow them, okay?
Yes, ma'am.
All right, good luck to you. Thank you. All right. All right, Antonio Garcia.
Did you mention last week that we were calling this? I know you wanted to speak to him about a violation.
State, have you had a chance to review this violation report? It's for Antonio Garcia. He's on page.
Week, Judge, if you want me to, I can remind him, or if you want to give me a couple of
Yes,
minutes.
yeah, I'll give you a couple of minutes. All right, if you'll step back, they'll call you back up. Sure. And what page is Rio's on? Yes.
So. Found out what's going on, the state
having trouble confirming the deductible
Yes.
PSA.
So they told me that that the complainant was in the hospital. At first they said, we don't have the information. So I said, okay, then there'll be no restitution. But immediately after I said that, then they said, hey, the advocate just got a text message. So they're not at 1,500. They say it's 1,000, but they say that the complainant is in the hospital.
That's what they told me.
So they don't have it right now. So are you okay with a reset? And your client can of course appear by Zoom?
That's fine, Judge.
All right, state on Ryan Rios, how much time are you requesting? Because I know you said the complainant was in the hospital.
She's undergoing some medical treatment right now. I did ask our advocate to try to reach back out to her to answer that question that you had, but she
Mhm.
hasn't responded. And if she's attached to machines and stuff, I don't know how much she can.
Okay.
So if you could give us at least just maybe a week, we can get an answer.
All right, Ms. Ferguson, if you recall this for 30 days, and counsel, if they have it before then and you all are able to confer off docket, then we can take care of it.
Okay, Judge.
Thank you, Your Honor.
You're welcome. Bashan, Ryan Rios on that restitution hearing, it's being recalled for October 13th. All right, Megan?
Yes, Judge.
So,
a chance for the violation report.
yes.
The violation report. I've had a chance to review it, and my review of it appears that the defendant just stopped at places he was not supposed to go, and so let Mr. Martinez offer explanation to them.
All right, so what do you want what do you want the court to do with regards to the violation report?
For the GPS violations, in my review of them, they're not extremely egregious. I would just ask for a sanction.
All right, are you employed?
Yes, ma'am.
What is your work schedule?
I work Monday through Friday, 3 to 11, and when weekends are posted, I send it to Mr. McQuarrie and he approves it for set time.
And just, this was a miscommunication.
Yeah.
Mr. Garcia's had his car repossessed, so he and his wife were down to one car. He got gas in her car, took her to work, and that was it. He had communicated with GPS, thought that issue I thought it was a non-issue. And so that's why we're having, at that point, we get the issue with the GPS thing. He's had some communications back and forth. He's tried to be as open and communicative with people as possible. There are occasionally some hiccups, but we found that if he keeps, number one, if he keeps communicating, and number two, if he's dealing with the same person, Mr. McCrory, that we typically don't have these issues. So he's apologetic to the court, but that's the crux of the issue.
It was 2 weekends in a row where he approved my going to work. And I'm literally either on the way or already at work. And first they call me from California, and then they call me from pretrial that I'm not approved for set work time, that I have to turn back home. So they've written me up, and I was on the verge of losing my job also because of said lack of communication. It's gotten better. And we're communicating on a much better level now. I had to sit down with him the last day I was here, when we were here, and he gave me the UA, whatever, and I passed, and we had a frank conversation.
So is there an issue with communication currently?
No, ma'am, I communicated this morning that I was gonna be in court, and if he needed me to go afterwards, because I have to go to the bondsman afterwards, if the court allows.
I mean, it seems like that part is good. His communication with Mr. McCurry is actually pretty good.
Okay.
The problem is sometimes things don't get put in the notes.
Yes.
And if he's going outside of normal hours that have been approved, sometimes it's not in the notes, and so they'll jump on him, and that's what was happening here.
Yeah, he went on vacation last week, and there was a new guy that I had to communicate with, and I went to work, and he says, "Oh, what are you doing? You're not scheduled to work." I said, "My schedule is Monday through Friday, 3 to 11. He said, "Well, he didn't put it in the notes, but let me fix it right now." And I said, out of curiosity, he already had approved the weekend, and did he put that in the notes? And he said, no. And he did it right there and then. So sometimes, I mean, I understand I'm not the only defendant, so sometimes it might miss, but
But certainly you're trying to communicate to them as well as you can.
yes, sir.
All right, and has he already completed the
I'm already set for the in-person assessment for bright lifetime recovery and all that.
he's reading my mind. Get out of my mind. All right, so here's my question, State. Do you all want to do maybe a tracking and specific areas he's not allowed to be in? That's just something to think about. If the issue is he's not being allowed to work, or either do tracking with a curfew.
Yeah, okay, let me just, I'm sorry, that's why you're asking me. And then-
Yes, yes, yes.
I'm sorry. Okay, yes, I will look at that.
All right, so guys, just have a seat and see if you all can come to an agreement, so maybe we don't have this issue again. And then come up when you're ready to approach.
Yes.
Yes. All right, Mr. Marine. All right, and you're saying, counsel, that you're requesting a continuance?
I am, Judge.
Okay, what's the reason?
So I had some family issues last week that kind of chewed up my whole week. And the week before that, I was in a murder trial in Carson City.
Okay.
And so I do need some additional time to prepare and get the witnesses ready and those sorts of things. But it's our first setting. I've conferred with the state on this.
Do you have any objection?
I'm not objecting, Judge, for continuance in this, at this time.
All right, Ms. Ferguson, if you can recall this in 2 weeks, please. All right, September 29th.
We do another day that week because I'm out of county, both Monday and Tuesday.
All right, Norma. He says he's out of county Monday and Tuesday. Are you able to do it that Thursday?
Yes. Yes.
All right, we'll be back on October 2nd for sentencing.
Thanks, Judge.
Thank you, Judge. May I be
Thank you.
excused?
Thank you for addressing appropriately. Once you sign the reset form, you're excused.
No excuse.
All right, Abel Hernandez. All right, so where are we on the Laurel Ridge records?
I actually do believe those are still outstanding. I didn't check on those, Your Honor. We had another issue come up with a juvenile proceeding that we need some more time on.
All right, when is the juvenile proceeding going to take place?
There is allegations that there is a juvenile case pending. That I don't know anything, other than she has confirmed that there is a juvenile case they expect to file against him. So that's all I know about that. So I would like to know more about that in addition to Laurel Ridge records.
All right, so this is going to be the last setting for discovery. If it's not tendered to the defense, then the court will consider whatever motions you wish to file, Mr. Bach.
Yes, Judge.
Ms. Ferguson, on this case, if I can have a 30-day reset for discovery.
Yeah, that's fine, Judge.
All right, so we're going to come back on October 16th. That'll be for discovery to make sure that your counsel has all of the information he needs to proceed, okay?
All right, thank you, Judge.
All right, thank you.
Thank you. Deputy Heath.
Judge.
You're welcome. Adriana Ayala. Are y'all ready to proceed?
Ma'am.
All right, court is calling 2020 CR 10020 State versus Adriana Ayala. Can I have parties announced?
Rick Pena for the state of Texas.
Judith Lemert for the defendant.
And are you Adriana Ayala?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney?
The document, I did.
Did you understand it?
I did.
Are you the same Adriana Ayala who was placed on community supervision in 2020 CR 10020 for the offense of assault family second offense on October 11, 2021 for a term of 2 years? Is that you?
Yes, ma'am.
All right, State, you may proceed.
Thank you, Your Honor. Violation condition number 41. On or about the 30th day of May.
Excuse me, I don't have a violation of 41. Is that a supplemental?
No.
Thank you, Ms. Abrams. Oh, I have the incorrect one.
Oh,
All right, you may proceed.
yes, Your Honor. Violation condition number 41. On or about the 30th day of May 2024 in Bear County, Texas, the defendant Adriana Ayala did then and there fail to comply with the rules and regulations of the Esperanza Court, in that the defendant absconded from the women's sober homes in violation of condition number 41.
How do you plead to that, true or not true?
State will waive the other violation. Your Honor.
Any objections to the
No, ma'am.
waivers? Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion and sentence you up to 2 years in the prison?
So he's supposed to be against me, she's supposed to be for me, why did you just give him some paperwork to be against me? If he didn't want the paperwork, it shouldn't have been filled out. Because it's not complete, is his records not complete? I just pointed something out to him on his paperwork. Because his paperwork that was in your hand, is not in his hand. No, I didn't get it. That's why he's reading it now. Because he didn't have it earlier.
All right, so this is what the state is accusing you of. They're accusing you are not following the requirements of Esperanza Court. Do you understand that? All right, you just pled true to that allegation, which is number 41. Do you understand that? And do you understand that the state is not proceeding on any other violations in the motion to revoke? They're only proceeding on violation of 41. Do you understand?
Yes, I am.
All right, so do you still wish to plead true to violation of condition number 41?
I do, yes, ma'am.
All right, by pleading true to violation of condition number 41, the court could sentence you up to 2 years in the prison. Do you understand?
Yes, ma'am, I do.
All right, the court is going to find violation of condition number 41 true. Is there a proposed agreement?
There is, Your Honor, that is to revoke the defendant's community supervision and sentence the defendants to 2 years TDC.
That is the agreement, Judge.
All right, the court will sentence you, the court will grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. Did she pay the $100 to the approved Family Violence Center? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Correct.
All right, you can lower your hand, state your name for the record.
Adriana Ayala.
Yes, did you pay the $100 to the approved Family Violence Center?
I don't remember. I did pay my $1,000
For the court?
Yes, ma'am. But I don't know what else was included to my dollars, but he said I didn't know, Mr. Patrick said and Thorpe said I didn't know any fines. So I'm thinking that might have been included,
Okay, let me ask.
but I'm not.
If I may, Your Honor, the court summary reflects that she did pay the $100.
All right, thank you. All right. So the court then, as previously stated, will give you credit for any time served. There's a affirmative finding of family violence. There's to be no unsupervised contact with minors, and the court will request the therapeutic community. Did you agree to that sentence?
Yes,
Are you waiving your right to appeal?
Yes, I am. You know that.
Yes, there was something you want to say?
I have an idea of how much credit time served I have. Do you have an idea of how much credit time served I have?
I can,
They will be able to tell, no, they'll be able to tell your attorney. The clerk will be able to tell your attorney how much time you actually have in. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
I did.
All right, because you waive your right to appeal, you do not have the court's permission to appeal.
Okay.
Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. Do you understand?
Yes, ma'am, I do.
And I'm sorry, also, as previously ordered in the agreement for probation, there's to be no contact with Cesar Rodriguez.
Okay, thank you.
All right, thank you. Good luck to you.
Thank you.
And Judge, but just for the record, I did let Ms. Ayala know that she does have credit for 578 days.
Okay, all right, thank you.
Okay. May I be excused?
Cindy, do you need a cough drop or anything? All right, James Francis. All right, yes, where are we on discovery?
Judge, this is our first appearance. I'll have to check my files to verify that I've received all the discovery from the state.
All right, was the state able to tender an offer or no?
They did tender an offer, Judge.
All right, Ms. Ferguson, if you can set this for 30 days for a plea deadline date. All right, so we'll be back on October 16th. At that time, you need to let the court know whether or not you've reached an agreement with the state. Do you understand? Do you have any questions about anything? All right, we'll see you then.
Judge, if I could impose on you that October is my drug court month, could we do that on the 14th?
All right, Ms. Ferguson, is the 14th available?
Yeah.
All right,
Thank you,
October
Judge.
14th.
Thank
You're
you.
welcome.
Thank
On that GPS issue.
Yes.
Judge, so we're okay with tracking it only with a curfew from 12:30 PM to 12:30 AM,
AM to PM.
AM to PM.
What, 12:30 a.m. to 12:30 p.m.?
Yes, that should allow him to work. And then we could supply documentation to GPS if he's got some weekend shifts.
Okay.
And then just continued no contact, have 2 names and then 2 addresses.
All right. So if you all will write that in the order for me and hand that back to me and I'll put it in the system. All right, thank you.
Thank you.
All right, you're welcome. Thank you for dressing appropriately for court.
You're welcome. Yeah, that's it.
All right. Mahmoud Al-Gadrab. All right, today is plea deadline date.
Your Honor, we have received an offer. My client has pending criminal charges in another jurisdiction. He has an attorney on those, and this attorney was just retained in Hardin County to represent him. And I'm trying to get with the attorney to see what can happen here and there. And I would just ask that we give him extra time.
All right, and why were you late for court?
I live in Houston.
Oh, he told me he got here, but he had to go to the bathroom.
Oh, no, he wasn't on time.
No, when he got here, he had to go to the bathroom before he reported.
No, I mean, he wasn't on time.
Yeah.
Yes, I
So,
know.
Next time, come into the court and then.
so Ms. Ferguson, on this case, set it for a jury trial date and plea deadline date, please. State, how long is this trial gonna last? All right, so it'll be a short trial, Ms. Ferguson. All right, so your jury trial date is gonna be November 12th, okay?
Thank you, Your Honor.
All right. All right, Christopher Armstrong. Are you all ready to proceed? All right, the court is calling 2022 CR 11229, State versus Christopher Armstrong. Could I have parties announced for the record?
Lauren Espinoza for the state.
David Rodriguez for the defendant.
And are you Mr. Armstrong?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Christopher M. Armstrong who was placed on deferred adjudication in 2022 CR 11229 for the offense of unauthorized use of a vehicle on February 6, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Your Honor, state is proceeding on violated condition number 2, which reads on or about the 3rd day of March 2025 in Dare County, Texas, the defendant Christopher M. Armstrong did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, state would waive all other violations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion, enter an adjudication of guilt and sentence to 1 year in the state jail facility.
All right.
That is our agreement.
All right, and has he paid the $600 to the complainant?
I believe he's got a zero balance according to probation's chief. He's paid everything.
All right, so probation, he's paid the restitution amount?
Judge, that is correct.
All right, awesome. All right, are you asking the court to follow this agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court then will grant the motion, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served. There's to be no contact with Apollonio Albizio, Albzio. There should be no unsupervised contact with minors. And the court will recommend the therapeutic community. Probation, is there anything else?
Judge, I did want you to be aware that he's got some days that were not counted in that. 168 days, I believe, and 7.
He successfully completed that, Judge.
All right. Legally, the court has to give you credit for any time in SATF. So the court will give you credit for successful inpatient treatment. And there should be $1,000 fine, time and money to run concurrently. Is there anything else with regards to sentencing?
Further, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You're gonna have to take care of your drug issues. If you don't, only 2 things can possibly end up happening. Either you're gonna spend the rest of your life at somebody's prison or in somebody's jail, or either somebody's gonna have to identify your body, because the last time you use may be the last time you use. You understand?
Yes, Your Honor.
All right, good luck to you. Thank you.
Thank you.
Oh, and all right, Melinda Gonzalez. All right, so these issues have been addressed?
Yes, Your Honor. We are agreeing to do that for alternate amending conditions, Your Honor, to add BIP and no contact with Maria Cristina Gonzalez, or Rodriguez, excuse me.
All right, we've already done no contact with Maria Rodriguez, right? Is that who it is?
Yeah.
So that's already been done. So has there been a violation with that, or is this somebody new?
Someone else.
So who is it this time?
And
It's the same, that's the same person that they put on there.
So-
Cristina Maria Rodriguez is my aunt.
All right, so has she been having contact with this person and she's not supposed to?
Your Honor, it's my understanding that the case that she's currently on probation for was a different victim of her father, and that's what the no contact order was in place for. The new number 1 that state filed is supposed to draw on is for this new Maria Rodriguez person. That's why I wanted to add the no contact order.
All right, so as a condition of her bond, she had a no contact order with her.
For bond, yes,
Okay.
we're making it part of probation terms.
Okay. What, we are here because I'm assuming the aunt didn't want to go forward or something?
Yes.
All right, so here's the thing. Do you want to go to the Bexar County Jail for a year?
No,
Then you need to learn how to keep your hands to yourself. Do you understand?
yes, sir.
And if you can't be around family members without putting your hands on somebody, then you shouldn't be around family members. And you're going to start on this BIP class. When can she start with the BIP?
Today?
All right, you're going to start with the BIP within 10 days, and I'm adding anger management too, because something's not clicking with
I
you.
took a class of anger management already.
Well, it
I-
didn't
I
help.
could-
I had requested after this incident, I had suggested
Okay.
she take it. If she,
So she's taken it since this has happened?
this was after the
Yes.
incident, correct?
Yes, Your Honor.
And she did the, court had some other
Here.
therapy classes the court wanted you to have done those 2.
All right, so you're gonna start on the BIP. And you had better start doing better with your anger management. I don't know, is there something more intensive than BIP? Obviously, she needs major treatment for anger management. Just BIP, Miss? All right, you're gonna start BIP within 10 days. If you don't start BIP within 10 days, a motion to revoke is gonna be filed. Do you understand?
Yes, Your Honor.
All right.
Judge, I have one other request. Upon the presentation of a affidavit from his dad requesting the court change it from no contact to no harmful or injurious. Wanted to see if the court would entertain that.
Not until she has
And this is,
done BIP
and
classes.
this is the issue. The dad is trying to help her because they have a child and trying to juggle everything. And don't want a situation where she winds up in trouble of him helping either pick up the baby or.
Oh, they need to do that through a third party. She needs to not approach the court requesting that until she has started BIP and taken some BIP classes. Then the court will consider it at that time.
I have the father here if you'd like to hear from him.
No.
Okay. All right.
So you need to make sure that you start, if you want the court to consider lifting the no contact order, then you need to get enrolled in BIP and you need to take some classes under your belt and give the court some sort of sense that you understand what your triggers are and why you're being violent towards other people. You understand?
Yes, Your Honor.
All right, thank you.
Thank you.
All right, court is calling. Oh, you can come up. Court is calling 2025 CR 007396. 2025 CR 005205. 2025 CR 007397. 2025 CR 005206. 2025 CR 007487. And 2025 CR 009295, State versus Freddie Gonzalez. Can I have parties announced?
Lauren Espinoza for the state.
Christopher Ramos for the defense and Paul Espejo for the defense. That's correct.
And are you Mr. Rodriguez? I'm sorry, Mr. Gonzalez? I said that because there's another document in front of me unrelated to this matter that has that name. Just one moment, it's taking me a while to get the cases lined up. All right, counsels, and each of the cause numbers, have you received all discovery and did you review it with your client?
We have.
Yes, we have.
All right, and each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the true bill of indictment with your attorneys? Did you understand it? State, and the cause number ending in 96, the unauthorized use of a vehicle, are you proceeding on that indictment as presented?
Yes, Judge.
And the cause number ending in 05, the theft of property 2,500 to 30,000, are you proceeding on that indictment as presented?
Yes, Judge. I'm sorry, you said 95?
05.
05, yes, Judge.
And the cause number ending in 95, which is manufacturing delivery in count 1. And in count 2, possession, are you proceeding on that indictment as presented?
No, Your Honor, in this case, we would move to waive count 1 and proceed solely on count 2.
We have no objection. Okay.
And the cause number ending in 87, are you, which is the evading arrest detention, are you proceeding on that indictment as presented?
Yes, Your Honor.
And the cause number ending in 97, the theft of property 30,000 to 150,000, are you proceeding on the indictment as presented?
Yes, Your Honor.
And the cause number ending in 06, the forgery of a government or national instrument or money security, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gonzalez, in each of those cause numbers, did you review the documents entitled Application for Community Supervision with your attorney? Did you understand it? Did you sign it and all? And did you sign it?
Yes, sir.
And each cause number?
Sure.
And the cause number 2025 CR 005206. You're charged with forgery. And cause number 2025 CR 007397. You're charged with theft of property. $30,000 to $150,000. And cause number 2025 CR 007487. You're charged evading an arrest detention with a vehicle. All of those charges are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And cause number ending in, I'm sorry, in cause number 2025 CR 009295. In count 2, you're charged with possession of controlled substance, penalty group 1. 4 to 200 grams, that's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? And cause number 2025 CR 005205. You're charged with theft of property, $2,500 to $30,000. And cause number 2025 CR 007396. You're charged with the offense of unauthorized use. I'm sorry, just one second. You're charged with unauthorized use of a vehicle. Both of those offenses are state jail felonies. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you are giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in this case? In each of these cases? Counsel, in each of the cases, has your client been able to provide you with any defenses?
Yes, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's, I'm sorry, do you believe he's currently competent and was legally sane at the time of the offenses?
I do. Yes.
Mr. Gonzalez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Do you understand by entering into these plea bargain agreements, if you are not a U.S. citizen, you may be deported, not allowed naturalization or re-entry into the United States? Did you understand?
Yes.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorneys? Did you understand it?
Yes, sir.
And cause number 2025 CR 007396. According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine. State recommends community supervision. This will run concurrent with 2025 CR 005205. There is to be restitution payable to the complainant. Outside the agreement, state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant. Did you understand that to be your plea bargain agreement in that cause number?
Sure.
Counsels, is that the plea bargain agreement under that cause number?
Yes, it is.
Yes.
And cause number 2025 CR 005205. According to the plea bargain agreement, punishments be assessed at 2 years in the state jail facility. There's a $1,000 fine. State recommends community supervision. It will run concurrently with 2025 CR 007396. There's restitution of $500 to Elizabeth Mascaro. Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand that to be your plea?
Yes, Your Honor.
Councils, is that the plea?
Yes, Judge.
Yes, it is.
Yes, Judge.
And cause number 2025 CR 009295. According to your plea bargaining agreement, the state is proceeding on count 2. Your punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. This will run concurrently with 2025 CR 005206, 005205, 007396, 007487, 007397. State will take in consideration 2025 CR 007488, 007406, 009170. Outside the agreement, the state is requesting your community supervision be for a term of 10 years. There'll be a TAP evaluation, 250 hours of community service restitution, and the MRT. Did you understand that to be your plea?
Yes, Your Honor.
Councils, is that the plea?
Yes, Your Honor.
Yes, Judge.
In cause number 2025 CR 007487. According to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine, no application for deferred adjudication. State recommends community supervision. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396. State will take in consideration 2025 CR 007488, 007406, 009170. Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 250 hours community service restitution, MRT, and the anti-theft course. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
And cause number 2025 CR 007397. According to your plea bargaining agreement, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine, no application for deferred adjudication. State recommends community supervision. This is to run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396. Take in consideration 2025 CR 007488, 007406, 009170, and there's to be restitution to Adam Vasquez. Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 250 hours community service restitution, the MRT, and anti-theft course. Did you understand that to be the plea?
Your Honor.
Defense
Yes, Judge.
and state?
Yes, Judge.
And cause number 2025 CR 005206. According to the plea bargaining agreement, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. This is to run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396. Taking consideration 2025 CR 007488, 007406, 009170 and restitution to Salvador Mascaro. Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 250 hours community service restitution, MRT, and the anti-theft course. Did you understand that to be the plea? Councils, is that the plea?
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph in each one of the cause numbers? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that cannot be, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
All right. And counsel, is your client plea going to be the same in each cause number?
No contest in each.
All right. And is that your plea in each cause number? No contest?
Yes.
And state in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor, in each cause number, state offers what has been marked as State's Exhibit 1 in all attachments.
No objections to the defense.
In each cause number, did you review the documents entitled trial court? I'm sorry, did you review the documents entitled waiver and stipulation of testimony with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You're going to need to speak up.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. In each cause number, the court will accept into evidence states exhibits 1 and attachments and review the same for sufficiency. All right, before the court, off the record for a moment, before I review this, have you all come up with an agreement on restitution amounts?
I believe on a couple of the cases, restitution is to be determined.
But so there's no agreement on those restitution amounts.
A total amount, that's not my understanding.
All right, so when will you have the restitution amount?
Within a few weeks, Judge, 1 or 2.
Okay, because what I can tell you, what I've learned is that we'll need the restitution paid up front because sometimes it doesn't get paid at all. Does everyone understand? So we're going to figure out what the restitution amount is in each case. And then we're going to, if the court follows the plea, we will see when that restitution can be paid.
What would be our next step?
Hmm?
What would be our next step from that?
Oh, let me see if this is sufficient or not to find him guilty. Then I will give you a date for that.
To return.
Mm-hmm. I just don't want anyone to not be aware of that. So that's my policy just based upon experience. You need to get that paid up front. Otherwise, sometimes it doesn't get paid.
Judge, just for future reference, let's say the state is not able to make contact with the complaining witness.
Oh, I give them time, and then if they're unable to receive a restitution amount, then we'll proceed. All right. So just give me a moment to review the steps. All right. In each cause number, the court is going to find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. State, when will you have the restitution amount?
Your Honor, 2 weeks will be sufficient if the court will allow.
All right. And if you can get with the defense, and if maybe you all can try to figure out approximately, so your client will be prepared to pay restitution. And if you all can come back and figure out why I should follow this plea bargain agreement, come back with reasons for the court to follow this agreement. So, Ms. Ferguson, I need a 2-week reset for sentencing. And are both parties waiving PSI?
We are, yes.
All right, so we're going to be back on September 29th at 9 a.m. And at that time, you all can explain to me why I should follow the plea bargain agreement. And if you all would confer off docket? Yes.
And I presume if he has an amount, we would pay that directly to the DA's office and they would forward the rest.
If you all speak with that, because sometimes it's easier for the DA's office to forward that as opposed to giving it to probation. Yes.
So we would be in contact with
Yeah.
the state.
We can talk.
Yes, and if you all can figure out if it's best for them to bring a cashier's check.
Yes, Your Honor.
All right, is there anything else?
Your Honor, I don't believe it was stated on the record, but the state's intention is also to take into consideration a misdemeanor case with this plea bargain.
Okay.
And that'll be 2025 CC 008476.
All right, and that'll need to be signed by the misdemeanor court judge. Okay. All right, is there anything else? All right, Ms. Ferguson, we'll give you the reset form.
Real quick.
Mhm.
I just want to make sure I understand what's going on.
Yes.
Lack of a better way of saying. The court's saying we should be able to give the court a reason why you should follow the plea bargain agreement. And I'm assuming the restitution is gonna have a lot to do with that. If we find out what the amount of the restitution is in 2 weeks, my client may not be prepared in 2 weeks to have that restitution right there and then. He is gainfully employed and he does have access to sums of money, but without knowing what that amount of money is and exactly how much he's gonna have to come up with.
Oh, I think you all will be able to do that off record, and I'm sure he has family support. This is what I've discovered in my time on the planet. Usually when people are looking at potentially prison, maybe, family members rally together to pay the restitution amount. And here's my thing, Mr. Gonzalez. When people have damage done to their property, and people who have caused damage to their property say, well, I don't have that right now. Well, the person who had damage done to their property can't afford to have damage to their property right now. You understand? So the person who had the Cadillac sitting on the side of the road, and now there's damage to that Cadillac, I'm sure they need their Cadillac without damages so they can drive it. So, yeah, that's where we are. So come back on September 29th. And if I'm going to follow this plea bargain agreement, I will expect on September 29th to have the restitution amount. So y'all need to confer off docket so that he will know the restitution amount he needs to come into court with in the form of a cashier's check or whatever you all accept in upstairs.
Yes, Judge.
All right.
The only thing I'm worried about, Your Honor, and I'm not trying to push the issue. If we find out on the 11th hour that morning what the amount of the restitution is.
They're not going to give you, she's already saying it's not going to be the 11th hour.
Okay. I just want to make sure that we're prepared to come in.
Oh, yeah. You're not going to have that on an 11th hour, are
No,
you?
Your Honor.
Yeah, Laura would not do that. All right, once you sign the reset form, you're excused.
I know Mr. Murphy, who also practices law in Texas. Mr. Murphy sometimes sticks his head up. What happened?
All right, so we're back on the record. All right, and cause number 2025 CR 006134. How do you plead to count two?
Culpable, guilty.
And in cause number 2025 CR 006193, how do you plead?
Guilty.
State in each cause numbers, do you have any evidence to support the plea?
Yes, Your Honor. State moves to admit would have been marked as State's Exhibit 1 and all attachments.
No objection to state warrant in fact.
All right, state you may be excused.
Thank you, Judge.
In each cause number, did you review the waiver and consent to stipulation with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each cause number, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
Then in cause number 2025 CR 006193, as previously stated, the court is finding you guilty. The court will sentence you to 15 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 006134. Taking consideration 2025 CR 006192. And there's to be restitution, if any, to the Bexar County Criminal Investigation Laboratory for drug testing. And there's to be no re-entry into the United States. And cause number 2025 CR 00613. As previously stated, the court is finding you guilty. All right, 2025 CR 006134. 15 years in the prison. Credit for any time served. There's a $2,000 fine. Time and money to run concurrently. This run concurrent with 2025 CR 006193. Taking consideration 2025 CR 006192. Restitution, if any, to the Bexar County Crime Lab for drug testing. And there should be no re-entry into the United States. Is there anything else with regards to sentencing?
Not from defense counsel, no.
Right. And each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you.
Thank you.
Thank you, Judge.
Thank you.
All right.
All right, who's here on David Aaron Jordan? And is there an application, counsel?
No, Your Honor.
All right, the court is calling 2024 CR 1409 State versus David Jordan. Can I have parties approach? And announce for the record.
Melissa Albin for the state.
Quick analysis, Mr. Jordan.
And are you David Aaron Jordan?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jordan, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Your Honor. Let me double check. I believe we are. Yes, we are, Your Honor.
Right. Mr. Jordan, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
By indictment, you're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Jordan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a United States citizen, this could result in your deportation, denial of naturalization, and reentry?
Sure.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. There's $1,000 fine. There are no applications. This will run concurrent with CC 724832. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
That is your honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers into evidence states exhibit 1 with all its attachments.
Any objection?
Objections, Your Honor.
Did you review the state you may be excused?
Yes, your honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
Right, anything you wish to say?
No.
All right, the court is going to sentence you to 2 years in the prison, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. This will run concurrent with County Court Cause number 724832. I'm going to request a therapeutic community, and there'll be no unsupervised contact with minors. The therapeutic community doesn't increase the time that you're in custody. It's to help you with any drug addictions you may have. You understand?
Yes, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record. Here's the thing. You're gonna have to get your life together. How old are you?
42.
All right, you're 42. You're about to enter that territory where more of your life is behind you, in front of you, and you're gonna have to make a decision how you want to live it. Now, it appears to the court, based upon reading the police report, you have a drug problem. When you are released from custody, if you cannot find a place that can help you with your drug addiction, if I am here, you can come back here and I will pick up the phone and find a place that will take you. You understand? All right, good luck to you, okay? Welcome. All right, Ms. Trevino, if you'll come forward. All right, so here's the thing. Number one, I can't act as an attorney for you on this, but I can just speak to you in generalities, all right?
Sounds perfect to me.
All right, so generally, in order to sign off for a request for occupational license, the court would need proof that you have insurance
Yes.
and that your driver's license is current. So, in reviewing this order, I don't have an attachment of your form stating that you have insurance.
Insurance, I believe it's BSR 22.
Mhm.
I can have that.
Okay, so it'll need to be with this because I don't have it. All I have is the order. I don't have your petition. So if you will speak to the coordinator, because maybe you filed it with your petition, or did you just do the order?
No, I filed it with the paperwork that I did send in. I
Okay,
know I had the insurance in there.
okay.
And
So this is what I need you to do then. If you will take this order to the clerk, because they need to pull the petition for me. So the only thing they've given me is the order. And it doesn't have any of that information in it, and I need that information, all right?
yes, ma'am.
So you can just talk to them.
Good, thank you.
All right, you're welcome. All right, are you all ready on DeAnthony Gordley? Court is calling 2025 CR 007068, State versus DeAnthony Gordley. Can I have parties announced?
Robert Ramirez from Mr. Gordon, Your Honor.
And are you Mr. Gordley?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Gordley, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gordley, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Gordley, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? I'm sorry, not are you a U.S. citizen, but did you they've changed the law. We're not allowed to ask that question anymore. So we have to do it in a roundabout way to make sure that you understand certain consequences. So if you're not a U.S. citizen, by entering this plea, you can be deported, denied naturalization, and not allowed re-entry into the country. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea? Defense, is that the plea?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there be any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There'll be 200 hours of community service restitution, no contact with the complainant, and no contact with 2400 North St. Mary's, the hostility management and alcohol awareness course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? How do you plead to the offense as charged? State, any evidence?
State offers states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into this plea bargain agreement, the state will be presenting evidence in the form of witnesses' statements and police reports. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask that you follow the plea.
All right, and so this location, where is this location? What is the business?
Nightclub,
And what's the name of the nightclub?
Rumble,
I'm sorry, what?
Rumble.
Rumble?
Yes, ma'am.
And what time did this happen?
I want to say around like 2 o'clock in the morning.
Mm-hmm. So that still goes back to my point. Nothing good happens really after 10. So had you been drinking?
No, ma'am, I wasn't drinking at the time.
So you were sober?
I did drink beforehand, but at the club, I was not drinking.
No. So were you sober?
No, ma'am.
So you were intoxicated?
Yes, I was.
So why didn't you leave when they wanted you to leave? The clubs, do they close at 2 a.m.?
I think they were closing.
There was a lot going on.
All right, what does that mean? A lot going on. Somebody asked you to leave a location and you don't leave.
We were actually leaving and it just, it was a fight going on. And
Between?
a lot of us. There was so many people out there, I can't even remember for real.
So do you know these other people? Devontae Manquel, German Scott?
Mhm.
Who is he to you?
It's my cousin,
Sergion Jarrell Knowles,
my brother.
Amy Arlene Garcia,
I don't know.
Serena Faith Estrada,
Brother's wife.
Anderson DeAndre Sledge V.
That's my oldest brother.
So let me ask you this, because these are things that people need to think about, right? How would you feel if someone were to spit in your face?
I feel bad.
And how would you feel if somebody wanted to spit in your face and their saliva landed in your eye?
Nobody else would feel.
And how would you feel if somebody spit in your face and their saliva landed not only in your eye, but it went in your mouth?
Like it.
Well, would you calmly just walk away or would you be prepared to fight?
I'd be prepared to fight.
All right, so this officer in this report says you spit on them.
Mhm.
And being intoxicated is no excuse to behave badly when people are telling you to leave their location. And it's 2 a.m. and everybody probably in your group is drunk. Was there not one sane, sober person in your group to say, let's leave, you all are acting crazy? Your brother's wife didn't say, I'll see you all and I'll let your mom know that you all are about to go to jail because you won't leave?
Mhm.
And do you have any children?
I have a daughter.
How old?
1.
1. So you have a daughter who is 1, and who was taking care of your daughter?
Her mother.
All right, and are you and the mother together? All right, so how do you think this is for your daughter? Her father is out at 1 a.m. I'm sorry, really 2 a.m. at a club. And how old are you?
26.
At some point in time, isn't it time to be done with being out at the club at 2 a.m.? And your brother and all these other people, how old are they?
Honestly, I don't know. People with their ages. I got 11 brothers and sisters.
All right, so you have 11 brothers and sisters. So these brothers that were with you this night, are they older or younger?
One of them older. They're my oldest brother, and then the other one is younger than me. He's actually 25.
So he's 25. So then the older brother who is older than you, estimate, what is his age?
30, 32, I want to say.
and still acting silly. And is your mom
She's deceased.
and your father?
Deceased.
So who is telling you all not to do this?
Nobody, honestly.
All right, so you're at that age, and I'm sorry that your parents have passed, but you're at the age where nobody should have to tell you this. Usually they say it takes males a longer time to mentally develop. But at the age of 26, you should already be there, and especially since you have a daughter who is dependent on you financially, and you're not doing good things.
You made a mistake.
No, not a mistake. You made choices.
I did. You're right.
Yeah, because you all chose to go out. You all chose to drink to intoxication. You all chose not to leave an establishment when it's already after 2 a.m. And you chose to spit on this officer. I can't even imagine how he's feeling. Can you imagine how that officer is feeling and how gross that is to have somebody spit in your eye? And not have any Visine drops, probably want to pour alcohol in your eye, but you can't. And then for it to go in your mouth, a complete stranger who's drunk. And I'm pretty sure that you all probably didn't smell great because you're drunk. You understand?
Yes, ma'am.
If you want me to follow this agreement, I will follow this agreement. But in this courtroom, probation is not easy. It's not supposed to be easy. And it's designed for rehabilitation. And what I can tell you, while you're on probation, you're not allowed to drink alcohol at all. Do you understand? Well, I mean, not that's fine. You're not allowed to. Do you understand? And you're not going to be out at 2 a.m. You should be, all of your waking hours should be setting money aside so that your daughter has enough money where she can do what she want to do, but not have too much money so she doesn't have to do anything. You understand? So the court is going to sentence you to 4 years deferred adjudication. There's going to be regular reporting by Zoom or in person. Regular random UAs. Are you currently employed?
Yes, ma'am.
What do you do?
I work at True Fit as a trainer.
Okay. Proof of employment within 30 days. No employment as a home health care provider or with minors. Do I need to go to True Fit and get in shape? See, I put you on the spot because you're like, I want to tell her the truth, but I don't want to get in trouble. All right, so there has to be no harm. Bashan, he's like, I want to tell her, Judge, hit the gym, but then I don't know how she's going to react. That's okay. I deal in truth. So there's to be no employment as a home healthcare provider or with minors. There's to be no contact with Brandon Stanley. All right, state.
Yes.
Brandon Stanley, is that somebody who's owns the club?
That is from associated misdemeanor. So we'd ask that you follow it just because he's gonna be on that, but not be on.
All right, no contact with Brandon Stanley or 2400 North St. Mary Street. 78212. You're going to write a letter of apology to M. Ramirez. And that's the officer, you understand?
Mm-hmm. Yes, ma'am. Okay.
So other than this alcohol issue, any other drug issues with you? There's going to be 200 hours of community service restitution. I'm going to require parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's going to be 30 sober support meetings in 30 days. Field visits 1 time per month for 6 months. And out of custody, you can do a TAP evaluation. If TAP recommends inpatient treatment, we'll start with supportive outpatient treatment. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, I do.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. You better start making better choices. And at your age and the responsibilities you have, you should be in the house by 10. Your club days are behind you. You understand?
Yes, ma'am, I do.
All right, good luck to you.
Thank you.
You're welcome. Noah Castillo. And then after that, I'll take up Ms. Trevino. All right, the court is calling 2025 CR 005604, State versus Noah Castillo. Could I have parties announce? And are you Mr. Castillo?
Yes, ma'am.
All right, State. Has there already been an acknowledgement of discovery on this case?
Ms. Acevedo's finishing that up right now,
Oh,
Judge.
thank you. Thank you. Counsel, have you received all discovery? And did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Castillo, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am, I did.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Castillo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with evading arrest detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Do you understand if you are not a U.S. citizen, by entering into this plea bargain agreement, you could be deported, denied naturalization, and not allowed re-entry into the country? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
I did.
And did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine. State recommends deferred. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor. State moves to admit what has been marked as State's Exhibit 1 in all attachments.
No.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, that means that the state will be presenting evidence in the form of witnesses' statements and police reports. But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor. Judge, we were just asking to follow up with her.
All right, how old are you?
21.
All right, what's going on with all the tattoos?
Honestly, can't really say, what's going on. It's just, the time of my life, it just, it's going a little wild.
When did you get the tattoos?
First tattoo I got when I was 13.
Okay, and the neck tattoo, what's the neck tattoo?
It's just the money sign.
All right, so what do these tattoos mean?
Nothing gang related, but a lot of them are just money. Really, all of it is really money.
All right, I'm gonna have you evaluated for gang affiliation. You understand?
Yes, ma'am.
Are you employed?
Not at the moment.
When's the last time you had employment?
It's about before I came in, I was doing construction, so I said about a month ago.
And how old are you?
21.
All right. And do you have any children?
Two.
How many? Age?
2.
And are you in their life? Do you live with them?
Yes.
How far did you go in school?
Graduated high school.
All right. And so what are you planning on doing with the rest of your life?
Just being able to support my family, just go back to work, and just do the best I can.
Right. And so with this offense, why didn't you just pull over?
I did pull over, but it was just misunderstanding with the police officer.
I mean, no, it's not a misunderstanding. They pulled you over because they said you were committing traffic violations. And I'm taking what's in the report as true because you stipulated to it. And it's obvious in the police report that there were traffic violations. They pull you over. You're sitting there, pulled over, and they ask you to step out and you take off. So why are you taking off?
If I'm being honest, at that point in time, I was using drugs.
Yes, please be honest.
I was using drugs at that time, so I was high at the moment. And I got paranoid and I left.
And then there was a weapon in the vehicle as well, in the glove compartment box.
Right.
And I'm assuming that was your weapon.
No, it was not.
Who's-
It belonged to my brother's girlfriend.
But you're the owner of the vehicle.
Weird.
Any other questions?
No, Judge, if I could just speak on that.
Yes. I'm sorry, one final thing. So the drugs you were using, what drugs?
I was smoking weed for the most part, and I was using ice as well.
All right. Anything other than ice?
No.
All right, yes.
I've represented this client, or Mr. Garcia, probably at least 6 months, not longer. I mean, at least since the inception date, Judge. And what I can tell the court is that he does have a good support system. He's here. I don't know, something happened with the bonds. I think they got off, or there was an FTA with the misdemeanor. And so that's why he's been in custody. But every other time, Judge, he has been here. He's been with his brother. He's been if I can't get a hold of him, I've always been able to get a hold of one of his family members. So I know that and we've had those conversations as far as his age, what he was doing at the time, and what he plans on doing, moving forward. I've had the conversations about his drug use. They are on him. I believe that he's sober now. He's always indicated that to me because we've had long conversations about that, specifically because of his age and the kind of drugs that he was using. So I've talked to him at length about that. But I can tell the court that I believe that he does have a support system that wants to see him succeed. And I think that they're going to do everything in their power to help him with regard to any services that the court deems appropriate, whether that's, attending this counseling or going here, going there. I know that they are his transportation. I know that they help with his employment, and communication.
You want to talk about leaving lifetime recovery?
Yeah, so, I did attend.
without
last time.
permission?
No, I had permission to
No, I mean,
leave.
they say you absconded.
No, I had actually talked to the person there at Lifetime and they contacted, the courts and that's how I got permission to leave.
Right, could you pull that for me, please?
Cause I was attending the.
It would have
inpatient.
been May 30th, 2025. And it would have been a fifth violation report. All right, you may continue.
And so I was attending the inpatient, and I told them I wanted to switch to outpatient. So they were, I don't know, somewhere.
So you told them you would like to be on outpatient. Okay. And then you missed court when Judge Angelini was here and you were on a PR bond. So. Why?
I just had a lot going on at the time, so kind of just was just all over the place, like I said before.
All right, that was June. So that really hasn't been that far from today in terms of drug use. All right, were you able to find it? Because I know a warrant was issued for him on a violation report because of absconding from Lifetime recovery. And usually when you're in treatment, they don't let you make choices of whether you want outpatient or inpatient treatment. And your attorney will tell you that because she does treatment courts as well. They usually don't give the person a choice and say, oh, we think you should be in inpatient treatment. What do you think? Oh, we'll give you outpatient treatment. Usually that doesn't happen.
So I'm aware how that might sound, but I did talk to the head person in the Lifetime. And she gave the okay as well.
All right, so what I can tell you, counsel. So this is what I'm going to do. Probation, it's going to be 5 years deferred adjudication. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. No unsupervised contact with minors. 150 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 50 hours of the community service hours will be deemed satisfied. If you enroll and complete some higher level of education or either trade school certification, the court will deem the remaining 100 hours satisfied. So you can either get a trade in something.
Yeah, so I actually, sorry, I did go to a trade school. That's how I got my high school diploma. through the
Well,
trade
you'll
school.
need to,
Get that
you can
information.
work 100 hours of community service restitution, or you can get some higher level of education or trade school certification. And since you already have your high school diploma, that's not going to count towards that. You understand? I'm going to want a referral, and this is to take place in custody. I'm gonna want a referral to felony drug court, and counsel, if you can talk with them. Since it's Monday, they'll probably be able to see you before the week is out and let us know whether or not you accept it. You need to be honest with them. Because if you end up testing positive or violating conditions on this probation, you're potentially looking at 10 years in the prison. You understand?
That's fine.
So in custody, I want a referral to felony drug court. And I'm going to want a TAP evaluation and probation. I think we discussed this previously. The gang evaluation, that takes a while, correct?
No, the gang evaluation is not considered on judge, but in addition to the gang evaluation,
Bless you. There's something going on in there. They need to change the filters. Okay, so gang evaluation and ISP evaluation in council, if they say with the gang evaluation, he doesn't qualify, then they'll just do ISP. There'll be field visits one time per month for 8 months. Probation, $1,000 fine, that will be prorated. Is there anything else that's needed? Is there anything you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Because you're on probation, you're not allowed to have weapons. So you're not allowed to have possession of guns. If you have guns in your house, then you need to make sure those are safely stored elsewhere because you're not allowed to have possession of them. And your attorney will speak to you about that. Do you understand? In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to the court. With regards to these evaluations, if you're dishonest with felony drug court and say, oh no, I don't have a drug problem, you know what's going to end up happening? They will send me an email and send the court an email stating that you've been rejected because you say you don't have a drug or alcohol problem. That will be noted on the docket sheet. And what that means is don't come back here saying that now I have a drug or alcohol problem. You understand? All right, good luck to you. You're welcome. In custody. All right, Matthew Martinez. Deputy Laura, could you make an announcement for Matthew Luis Martinez? All right, thank you. All right, the court is going to call 2025 CR 005084 State versus Matthew Luis Martinez. Could I have an announcement for the state?
Rick Pena for the state of Texas.
All right, this hearing was scheduled at 9 a.m. The defendant did appear at 9 a.m. The defendant's counsel did not appear. The defendant did not return for docket. This case was set for sentencing on September 8th, 2025. On September 9th, 2025, the defense attorney was a no-show. September 8th, 2025, the defense attorney came but left and did not return. September 10th, 2025, the defense counsel was a no-show. September 11th, 2025, defense counsel was a no-show. September 12th, 2025, the defense counsel was a no-show. And September 15th, 2025, the defense counsel was a no-show. Request from the state.
Forfeit the bond, Your Honor, and issue judge's warrant.
All right, the court will issue a judge's warrant and remand the defendant without bond. All right, and I believe that is everything.